Hi everyone, my name is Wandile Mpachele. I'm a legal officer at PSA. This session is just to update members and everyone about the recent developments that came about as a result of the Constitutional Court judgment that was delivered in October 2025 dealing with maternity and paternity leave as a result of pregnancy. Maybe the good point to start is to first state that maternity leave and paternity leave are regulated by the Basic Conditions of Employment Act, what we call BCA. Previously, before this Constitutional Court judgment, mothers had 4 months maternity leave prior and after to giving birth, and fathers were afforded 10 days paternity leave. That was the position before this judgment. So then there came this judgment of Van Wyk versus Minister of Employment and Labor. In this case, to summarize the facts shortly, is that Mr. and Mrs. Van Wyk are married, and they had a child that was born between them. Mrs. Van Wyk, as a matter of profession, is an entrepreneur, and Mr. Van Wyk is a salaried employee. What had transpired is that after giving birth, Mrs. Van Wyk had wanted to go back to work, and Mr. Van Wyk wanted to take responsibility of the child whilst his wife went back to work because she was an entrepreneur. Mr. Van Wyk applied for paternity leave at work, but it was declined, obviously because the Basic Conditions of Employment Act only allowed him to take 10 days, and he wanted to take 2 months of paternity leave because his wife had wanted to take only 2 months and go back to his business. Now, that is where the dispute arose. Mr. Van Wyk then challenged Section 25 of Basic Conditions of Employment Act, alleging that the act discriminates against fathers because they don't have equal rights when it comes to paternity leave to take care of their child after the birth of their children. The High Court in that matter in October 2023 ruled in favor of Mr. Van Wyk and confirmed that actually the Basic Conditions of Employment Act is actually discriminating against fathers by not giving them equal rights in terms of leave after giving birth of their children. The matter had to be in terms of the legal system, in terms of the constitutional democracy that we are in. High courts cannot on their own give effect to validity of sections in any statute. So the matter had to go to the Constitutional Court to confirm the validity or invalidity of Basic Conditions of Employment Act. Now, the Constitutional Court in October 2025 delivered its judgment, and it confirmed what the High Court stated. The Constitutional Court also confirmed that the Basic Conditions of Employment Act, as it is discriminating against fathers. So the effect of that is that, as it is now, the Constitutional Court directed the following changes. Starting with the definition, there's no longer what we call a paternity leave or maternity leave. The leave dealing with the birth of a child is now called a parental leave. So we now call it parental leave. In terms of the judgment, the court directed that the 4-month parental leave between the mother and the father will be shared amongst themselves. So in total, both parties have 4 months and take 10 days to share in between them in terms of exercising those rights. So this session is important to clarify the misconception around that the Constitutional Court stated that both the mother and the father are entitled to 4 months leave after giving birth. That is not the case. The actual situation is that they both have to agree in terms of how they are going to use this 4 months, 10 days leave that is given to them as parents after giving birth. But what people must be mindful of is the fact that the mother, after giving birth, can only go back to work after 6 months. If she feels that she needs to go back to work before the expiry of 6 weeks, then the mother will have to get a medical certificate to confirm that she's fit to go back to work. So the effect of this judgment also has an impact on the Unemployed Insurance Fund Act, which gives benefit to mothers who go on maternity leave for 4 months, because obviously then mothers in the past or currently, even now as we speak, they have a right to claim from the UIF when they are not working, when they are still at home and nursing their children. But in relation to that, the Constitutional Court directed that the Parliament must amend the UIF Act to be in line with the changes that they have directed. So that is the current situation as the Court has directed. One, it is that the leave is now called parental leave for both parents. And two, both parents can decide how to use their 4 months, 10 days leave in between the two of them. So it's not only that mothers are entitled to 4 months, but parents can agree in terms of who wants to take the 4 months or whether they still use the old system. It's between the parents. Now, in relation to the public sector where PSA operates, the resolution dealing with parental leave will have to be amended to align with the new dispensation after the Concord judgment. So I will assume that the collective bargaining will table the matter because the collective agreement must align with the new Concord judgment and the amendments that will be effected to the Basic Conditions of Employment Act.